3, 2, 1, start. The petitioners contend that the tribunal has committed an error by allowing the claim petition in view of the fact that the claim of the respondent number 2 had already been rejected as he himself had voluntarily refused to take up the job of a sweeper, and therefore the respondent number 2 cannot claim compassionate appointment as a matter of right. It is further submitted that several reasons have been given while passing the order that the vacancies were not available within the 5% quota, and the appointment on compassionate ground is not a matter of right, and further respondent number 2 and his family was financially well off so as to provide enough aid, and hence compassionate appointment was not permissible in view of the guidelines framed by the government policy. Another reason given is that the claim is on account of death of respondent number 2, and therefore the compassion did not exist so as to give rise to any claim. Sri I.P. Srivastava submits that the answering respondent was prepared even to perform the job of a sweeper, and the appointment of the answering respondent was cancelled by order dated 14th November 1998, which is bereft of any reasons. He further submits that so far as the subsequent order dated 4 July 2002 is concerned, the same reflects non-application of mind, inasmuch it does not even refer to the earlier offer of compassionate appointment made by the respondents, and further none of the aforesaid contingencies are available for denying compassionate appointment as have been indicated therein. He further submits that the answering respondent is even now prepared to accept the job of a sweeper, and his claim survives inasmuch as he had approached the authority well within time. Having heard learned counsel for the parties, it is evident that the claim for compassionate appointment was made immediately after the death of the father of the answering respondent. The said claim was processed and the appointment was offered to the respondent. It appears that another application had been moved by the answering respondent on 22 May 1998, which was a long pending consideration for being appointed as a Mazdoor. The answering respondent appears to have made a request to the authorities that he would be unable to perform the job of a sweeper due to fear of a social boycott, and therefore he may be offered the job of Mazdoor. The cancellation order of 14th November 1998 appears to have been made only after such request had been made. The said cancellation order, coupled with the subsequent rejection on 4th July 2002, were challenged by means of an application before the tribunal, and the tribunal, after considering the submissions raised, allowed the claim of the petitioner, quashing the aforesaid two orders, and the authority was directed to reconsider the applicant for appointment on the post of Mazdoor, and in the interregnum period was also directed to allow the respondent to continue as Safaiwala. Stop.